the judgment, the claimant also in his submission formulated 4 issues for resolution. The argument of the issues have been captured in the body of the judgment. The claimant filed a reply, the defendant filed a reply on points of law to the submissions of the claimant. The said reply has been captured in the body of the judgment. I now go straight to the decision of the court to save time.
As the court pleases.
I have considered the processes filed in this suit, the evidence laid at the trial, and the written and oral submissions of counsel for the parties in support of their respective position in the originating process commencing the suit, i.e. the general form of complaint, its accompanying processes. The claimant is seeking for grant of 4 reliefs, 2 of which are declarations, while the remaining 2 are ancillary or dependent on the grants of the declaration sought. They are for payment of unpaid salaries and exemplary damages in the sum of 50 million naira. The law is well settled that when a dispute is presented to the court for determination, the parties as well as the court who is an arbiter are bound by the case as presented by the parties. In the case of the claimant, his statement of facts or claim, as the case may be, while for the defendant, the counterclaim, where there is any. The court, as in this case, there is one in this case, the court and the parties cannot depart from the case before the court. Therefore, for a claimant to succeed on his claim and the defendant to succeed on his counterclaim, the law impose a duty on them to adduce sufficient, cogent, credible, admissible evidence in support of their respective claims before the court. While the duty of court after evaluation of the evidence adduced is to grant the reliefs that have been proved. In the exercise of the court duty, the court can grant the reliefs as claimed or grant less, but cannot grant more than what was claimed or what was not claimed by the parties. See the case of ATB versus Capital Metal Nigeria Limited. The rationale behind this principle of law is that the parties and the court must abide by the case as submitted to the court. As in litigation, parties and not court are the owners of the facts and owners of the case. Therefore, the court has no justification to extend or expand the boundaries of litigation beyond what the parties have indicated that it is. In other words, the court has no justification to set up a different new case for any of the parties. Therefore, the court is not allowed to veer off the tangent from the reliefs asked by the parties to the case. This means under no circumstance should the court grant what was not claimed. The law forbids gratuitous award by the court, contrary to the rules of practice and pleading. This is to ensure fairness and fair hearing to the parties without showing favor to any of the parties. The rule against unsolicited or gratuitous award by court is of general application to all cases as it affects or robs the court of jurisdiction to make such award. See the case of Ekpenyo versus Indon, Adefulu versus Okolaja, Lewis and Fit Limited versus Akim Meli, Makanjola versus Balogun, and host of other cases cited there. It is tried law that a court has to confine itself to the relief sought by the parties and not act like Father Christmas. See the case of BEC versus Nigeria Limited versus Trade Bank PLC. See also Colonel MB Khalil versus Alaji Aleru. See also Anthony versus Government of Lagos State. Under our adjudicable system of adjudication, the claim is in an action is the sign of sure. It is the pivot of the case and set out the reliefs or relief sought by the claimant. See the case of Osuji versus Ekiocha. As pointed out earlier, at the risk of repetition, it is Homebook law that a court is bound by the relief sought in the action, and the generosity or charity of a court of law is confined strictly to the relief sought by the claimant and in the counter claim by the counter claimant. A court of law is not Santa Claus or charitable institution and cannot give a party what he did not claim. See the case of Dumes Nigeria Limited versus Nwakoba. Therefore, in determining the claim of the claimant and the counter claim of the defendant, counter claimant, this court will be guided by the settled principles of law on determination of claim. In abiding by the dictate of the law, I am constrained in this case to restrict my consideration to the case put forward by the parties, i.e., the claim of the claimant as per the statement of facts and the counter-claim as encapsulated in the defense. I cannot depart from the relief sought by the claimant or the counter-claimant, as they are the owners of their own case and knows better what they want from the court. It is the law that this court has no business delving into issues on which which no claim has been sought by the parties. Generally, a court of justice should not grant a party should not grant to a party what he has not claimed, but where the relief or order appears incidental and is necessary for proper and just determination of the cause, such an order or relief could be made, though not claimed. See the case of Ogbe versus AC. See also the case of Inaji versus Chuku. I note in this case, both the claimant and the defendant have dedicated chunk of their argument on issue of dismissal and termination, which they have used interchangeably to mean one and the same thing. In our labor jurisprudence, those two terms, dismissal and termination, and do not connote one and the same thing. The term termination of employment denotes the complete or absolute severance of an employer-employee relationship. Contrariwise, the terms dismissal denotes the release or discharge of a person from employment. In both cases, termination and dismissal, the employment of an employee is brought to an abrupt end, although with varying consequences. Where a contract of employment is terminated, the employee is accorded the privilege of receiving terminal benefit provided for under the terms and conditions of the employment. The right to terminate a contract of employment is mutually inclusive in that either party thereto may exercise it as well. Conversely, dismissal of an employee is punitive, very often than not, result in loss of terminal benefit. It equally carries an unpleasant opprobrium to the unfortunate employee. See the case of Jumbo versus PEFMB. See also the case of First Bank of Nigeria PLC and Ineka. See also Adeco versus Jebu Ode District Council. See also UBN versus PLC versus Suarez. Before delving into determination of the claim and the counter claim, I shall endeavor to first determine the competence of Relief V as contained in the statement of fact. The counsel for the defendant, while advancing argument on issue 2, has submitted that there is no doubt that Relief V sought has flavor of fundamental human rights infringement, and it only crystallizes when it relates to any dispute over interpretation and application of provisions of Chapter 4 of the Constitution as it relates to employment, labor,
Say
industrial
here.
relation, trade union,
Yes.
employers
Sequence.
association.
I say
Council continued his submission by referring to Section 6, subsection 5,
they said
subsection CC
voice for move
of
as
the
a school.
Constitution as amended, which establishes and vests this court with jurisdiction to entertain matters captured in Section 254C1A to M, subsection 2, subsections 2, 3, and 5. Counsel submitted that this court does not have the requisite jurisdiction to grant relief B of the claimant's statement of facts because the subject matter for which the relief is hinged on is not within the ambit of Section 254C of the Constitution as amended. A reply to the submissions of the dependent on fundamental right, counsel for the claimant refers to the provisions of Section 254C1A and D of the Constitution as amended and submitted that this court is closed with requisite jurisdiction to hear this case. Reliance was also placed on the cases of counsel, Federal Polytechnic Movie versus Dingoli, and the case of Federal College of Education Technical Gusau versus Abubakar. The issue raised by counsel for the defendant on relief B borders on jurisdiction. The law is well settled that where issue of jurisdiction is raised, the court must look at it before delving into the main issues for determination. Jurisdiction is the authority which a court has to decide matters that are litigated before it, or to take cognizance of matters or issues presented in a formal way for its decision. Such authority of the court is controlled or circumscribed by the condition precedent created by the legislation, which must be fulfilled before the court can entertain the suit. It is the power and authority of a court to hear and determine judicial proceedings and power to render particular judgment in the course of action. See the case of Arnaud de Joby versus MBA. Jurisdiction has also been described as a threshold issue and live wire that determine the authority of the court of law or tribunal to entertain a case before it, and it is only when a court is imbued or compared with the necessary
Giving a
jurisdiction by the
judgment.
Constitution or law that it will have judicial powers and authority to entertain, hear, and adjudicate upon any cause or matter brought before it by the parties. Where a court proceeds to hear and determine a matter or issue without the requisite jurisdiction, it amounts to an exercise in futility, and the proceeding and judgment generated therefrom are null and void and of no effect whatsoever, howsoever well conducted. In the instant case, for this court to have requisite jurisdiction to hear and entertain relief B, which borders on fundamental right, it must be shown that the relief is one that is cognizable under the provisions of the Constitution, under Section 254C of the Constitution, which delineated the subject matter of jurisdiction of this court. In civil matters, what determines jurisdiction of the court is the claim of the claimant. This means that the court will consider the claim of the claimant and the relief sought in order to discern whether the reliefs are within the ambit of jurisdiction of the court. See the case of SCC Nigeria Limited versus George. The Supreme Court has settled issue of the court having jurisdiction in fundamental right proceedings, as the jurisdiction is donated by Section 46 of the Constitution as amended. By virtue of Section 46, any person who alleges that any provisions of Chapter 4 is being or likely to be contravened in any state, a relation to him may apply to a high court of the state for redress, subject to the provisions of the Constitution. A high court shall have original jurisdiction to hear and determine any application made in persons of the provisions of the section, and may make orders, issue such writ, and give such directives as it may consider appropriate for the purpose of enforcing or securing enforcement within the state of any rights of which the person who makes the application may be entitled to under Chapter 4 of the Constitution. See the case of SCC Nigeria Limited versus George Sufra. See also the recent case of the Supreme Court in SEC Nigeria Limited versus Joseph. It is clear from it is It is clear from the case law that the approach of the Supreme Court to enforcement of fundamental rights has been a liberal one. So the Supreme Court has taken the position that irrespective of subject matter and parties before the court, the Federal High Court, the State High Court, and High Court of the Federal Capital Territory have concurrent jurisdiction to entertain fundamental rights. See Section 46 of the Constitution of the Federal Republic of Nigeria as amended. In other words, the provisions ensure that an applicant has access to the High Court for enforcement of infringement of his fundamental right. What is important that the real grievance of the applicant is the breach of fundamental rights protected under Chapter 4 of the Constitution, and not bail attempt in seeking redress for other generic civil rights or specific rights such as employment or property under the guise of enforcement of fundamental rights. The rationale behind the approach is that because of the essential nature of the fundamental rights, which must be jealously guarded, the premise of the Constitution have deemed it fit to ensure that there is no cloak placed on it in its enforcement. Consequently, it hopes on courts saddled with the responsibility of interpreting the law to adopt the purposive approach such that the provision of the Constitution should be construed in a matter to remove any fetters in the way of enforcement of fundamental rights. However, in spite of the jurisdiction conferred on the High Court of a state, the High Court of Federal Capital Territory, or the Federal High Court on to entertain application for enforcement of fundamental rights, by virtue of the provisions of Section 254C1 A to D of the Constitution of the Federal Republic of Nigeria as amended, notwithstanding notwithstanding the provisions of Section 251, 257, 272, and anything contained in the Constitution, and in addition to such other jurisdiction as may be conferred on it by an act of National Assembly, the National Industrial Court shall have an exercise jurisdiction to the exclusion of any other court in civil causes and matters relating to or connected with any dispute over interpretation and application of the provisions of Chapter 4 of the Constitution as it relates to any employment, labor, industrial relation, trade union, employers association, or any other matter which the court has jurisdiction to hear and determine. The provision specifically relates to the exclusive jurisdiction of the National Industrial Court on application or interpretation of Chapter 4 of the Constitution. It can be conveniently divided into two parts, relating to or connected to with any dispute over interpretation and application of the provisions of Chapter 4 of the Constitution, and it relates to any employment, labor, industrial relation, trade unions, employment association, or any other matter which the court has jurisdiction to hear and determine. The first part means that the National Industrial Court can entertain any suit in which the provisions of Chapter 4, that is Section 33 to 45 of the Constitution, will be interpreted or applied. On the second part, which reads as it relates to any employment, the operative phrase is as it relates to. And the relevant question to ask is whether relief being sought by the claimant relates to the claimant's employment with the defendant. Consequently, Section 254C1A and D of the Constitution confer on the National Industrial Court the exclusive jurisdiction to the exclusion of other coordinate court such as State High Court, Federal High Court, and Court of Federal High Court to entertain such a matters that relates to employment, labor, and industrial relations. See the case of SEC Nigeria Limited by Sir George Supra. This means this court can exercise original jurisdiction irrespective of reliefs relating to infringement of fundamental rights. In other words, the provision of Section 254C1 and D of the Constitution, as amended, empowered this court to entertain the question of fundamental rights, but however qualifies the nature of the question of fundamental rights contained in Chapter 4 of the Constitution, in which this court can entertain. The question is that such fundamental right question must arise from employment, labor, industrial relations, trade unionism, employers association, or any other industrial relate or any other matter which the court has jurisdiction to hear and determine. Thus, if a fundamental right question did not arise from the foregoing, the suit would not have any foothold at the National Industrial Court, as this court is only empowered by the Constitution to entertain fundamental right issues that emanate from the above listed areas of jurisdiction in Section 254C of the Constitution. For avoidance of any doubt, a fundamental right issue which does not have any coloration of the above listed areas of jurisdiction of the court can only be instituted as the competent state high court of federal capital territory, or federal high court, as the case may be, which has jurisdiction to entertain such an action. I have scrutinized Relief B of the statement of facts, as well as the entire statement of facts by paragraph 15 of the statement of facts. The claimant about that on the 19th day of May 2020, while he was in his house at Mpamosi, the police arrested him and detained him at Area Command, Akampa, Cross River State. Cross River State for 3 days. And by the paragraph 16 of the said statement of fact, the claimant stated that upon his release from custody, he tried to go back to work, but was stopped by the site manager of the defendant, who said he was acting on instruction of the second defendant, who has been the second defendant, a party that had been struck out of this suit. Even he also stated that he even complained to the human resource manager, Mr. Christopher, and which has not helped matters. He continued that Mr. Joseph Okon Epion merely told him that he has been suspended. The claimant by his abandonment in paragraph 19. In paragraph 19 of the statement of fact, has stated that he only reported a fraudulent practice to management of the defendant, and for whatever reason he was arrested and detained at the behest of the defendant. As pointed out earlier, in determining issue of jurisdiction, the court must do so by juxtaposing the relevant provisions of the Constitution with the abandonment contained in the statement of claim. See First Bank of Nigeria PLC versus Abraham. See also Ademi versus Opeyori. This is to say, if upon a proper evaluation of the statement of claim, it is shown that the dispute is labor-centered and or employment-related. In substance, jurisdiction is solely reserved for the National Industrial Court to the exclusion of other courts. However, where the dispute does not have its crux, heart, or core issues relating to the contract or connected with labor and employment as circumscribed or bounded by Section 254C of the Constitution, then the relevant High Court, other than the National Industrial Court, will be seized of jurisdiction on the matter. I take the view that it is apparent from the facts about in the statement of facts as captured above that the claim of the claimant on arrest and detention of the claimant is connected are related to his employment. In the circumstances, the said relief B falls within the ambit of Section 254C 1A and D of the Constitution, and this court has the requisite jurisdiction to entertain same. Having disposed of the preliminary objection of the defendant, I shall now turn to determination of the claim and the counter-claim before the court. I have earlier in this judgment reproduced both the claim and the counter-claim. In the circumstances, there is no need for me to reproduce them here. Coming to the determination of the claimant case, the claimant in reliefs A and B is seeking for court to declare as illegal verbal suspension of claimant, which is unknown to the policy of the defendant, which he claimed was on the instruction of the second defendant, whose name has been struck out of this suit. While in relief B, he is seeking for a court to declare detention of the claimant by the defendant at Nigerian Police Area Command Akamfa illegal. Relief C is for the order directing defendant to pay claimant his unpaid salaries from the time claimant was detained or suspended till the disposition of this case in court. Relief D is for the sum of 50 million naira exemplary damages for illegal detention, suspension of the claimant, and slandering of the claimant. Reliefs A and B are for declarations. The law is well settled that a claimant seeking for declaratory relief must succeed on the strength of his case and not on the weakness of the defendant's case. Therefore, the burden of proof on claimant is heavy in the sense that even on admission by the defendant, such a declaratory relief is not granted where he fails to establish his entitlement to the satisfaction of the court declaration by evidence. The court will not grant such declaration. So a claimant is not allowed to point fingers at any weakness, omission, or default on part of the defendant. He must stand or fall on the strength of his case. Therefore, the claimants cannot rely on any admission or deemed admission as proof of his entitlement to declaration. If his case is strong, he wins, and if his case is weak or shaky, then he loses. In the instant case, the claimant claimed two declaratory reliefs, while reliefs C and D were predicated on success of the two declaratory reliefs. Therefore, there was a legal burden on him and not on the defendant to prove to the satisfaction of the court that he is entitled to the declaratory relief sought. See the case of Kodile versus Odu. See also Ebumi versus Agbe. See Dumes Limited versus Wakoba Sufra. See also Attorney General of Rivers State versus Attorney General of Bayelsa State. See also Obe versus Abubakar. See also Maramro versus Oye Goke and Akande versus Adisa. See also Emenike versus PDP and Obe versus MTN Nigeria Communication Limited and Makinde versus Adekola. Now, the question that need answer is, has the claimant discharged the burden of proof imposed on him by law to entitle him to grant of declaration being sought? The first declaration borders on suspension. The claimant stated that one Mr. Joseph Okon Epion, site manager of the defendant, informed him verbally that he had been suspended on the instruction of the second defendant, a party that had been struck out of this suit. He further stated that this was despite the fact that that he complained to Mr. Christopher, the human resource manager of the defendant, but it was not helpful. The defendant on his part denied suspending the claimant from work. With the denial, issues have been joined on verbal suspension, which will necessitate claimant going beyond his ipse dixit by adducing cogent, convincing, credible evidence in proof of the alleged verbal suspension. In the circumstances, the claimant ought to go further to adduce evidence of corroboration to corroborate his oral evidence on the alleged barber suspension. The site manager, whom the claimant alleged informed him of his suspension verbally, was not called to testify regarding the alleged oral suspension. Likewise, the human resource manager, Mr. Christopher, whom the claimant alleged he complained to on the issue, was also not called as witness, and the alleged complaint was not tendered in evidence before the court. Since the claimant alleged that the verbal suspension was on the instruction of another person, not the defendant, evidence of such evidence of such verbal evidence of such instruction ought to have been given, but no such evidence was given by the claimant. The defendant in its defense, apart from outright denial of suspending the claimant from work, has stated that the claimant absconded himself from duty without justification, which rendered him liable for dismissal. The claimant did not counter this damaging assertion of the defendant, where in defense new issues were pleaded. Those new issues must be countered, but the claimant decided to remain silent on them. This means the claimant has accepted all the new issues raised in the defense as the correct position. The law remains that where a claimant fails to file a reply to abatements in a statement of defense which has not been taken care of by the abatement in his statement of claim, he would be deemed to have admitted the abatement in the statement of defense. In the instant case, the claimant pleaded that claimant absconded from duty without lawful justification, but the claimant failed to file a reply to the said specific pleaded abatement. In the circumstances, the claimants the claimant is deemed to have admitted the abatement of the defendant and taken as correct. See the case of Adeleke versus Aserifa. See also Iuha versus Nipos Limited. This position of the law is because it is certain that a court of law has no duty to infer denial, and therefore a fact which has not been specifically denied or traversed remain unchallenged. See the case of Eko Oduma versus Ume Inachi. See also Ajibade versus Maiwa and another. See also Attorney General of Anambra State versus EM Onus Lebu Enterprises Limited, and the case of Zagubo versus Pare Pare versus Pare Pare. Let me quickly say here that in evidence there is no evidence adduced by the defendant to show that the claimant had his employment terminated or dismissed from service, as the case may be. I have scrutinized the staff handbook which governs the relationship between the claimant and the defendant. There is nothing therein on deemed dismissal from service. This is because dismissal is a product of disciplinary action, and there is nothing before the court to show that the defendant has set up machinery in motion for taking disciplinary action against the claimant for him to be found guilty for misconduct and liable to be dismissed. There is also nothing to show claimant was given opportunity to defend himself against any allegation of gross misconduct for him to have been found guilty of gross misconduct and liable for summary dismissal. There is also nothing to show claimant was terminated, as there is no evidence that he was given requisite notice for termination as required or paid salary in lieu of notice. However, the conduct of the claimant by unilaterally staying away from work clearly shows that the claimant is no longer interested in the relationship, in the employment relationship. What the defendant is entitled to in such kind of situation and circumstance is to claim damages from the claimant for wrongful disengagement, which he has not done so in this case. Under the Nigerian labor law, parties are bound by the terms of their agreement as held in Elizabeth versus Ondo State Judicial Service Commission and another. An employer must comply with existing regulation and the contract of service before suspending an employee for disciplinary purposes. Since the dependent employee handbook governs the relationship, any disciplinary action, including suspension, must follow written procedure. A verbal suspension being outside the contemplation of written contract SBC will constitute a breach of terms of employment, but claimant has not been able to convince the court that he was verbally suspended. This means he cannot be entitled to payment of salaries for the periods he had been away from work. The principle of no work, no pay generally applies in employment relationship. However, if an employer is ready and willing to work but is illegally an employee is ready and willing to work but is illegally suspended or prevented from doing so by the employer, the employee is entitled to his wages. In the case at hand, having found that the claimant has not proved illegality of his suspension, this court, having not proved that he has been suspended, this court cannot order payment of salaries. It is only when suspension is found to be illegal that claimant will be entitled to his emolument as if he had not been suspended. The claimant having not proved that he has rendered services to the dependent from 19th day of May 2020 up to the time of filing of this suit in court, he cannot be entitled to any unpaid salary for the period of his absence when he has not rendered any service to the dependent. Having found that the claimant is not entitled to relief A, relief C, and part of relief D on suspension being ancillary to relief A must all fail. This is because it is settled law that the failure of mere relief means failure of ancillary reliefs. See the case of Udo and others versus Ogudu and others. See also the case of McDonald Scientific Emporium Limited versus Access Bank Limited. The failure to prove the main declaratory relief sought means ancillary reliefs of payment of unpaid salary and damages having no basis because they cannot be awarded in vacuum. On relief B, which is declaring arrest and detention of claimant for 3 days to be illegal, this relieves alleged violation of fundamental rights of the claimant against arrest and detention. The mere reporting of a matter to the police for investigation does not render informant liable for subsequent arrest and the detention of the suspect, provided that the report was made in good faith. The law imposes duty on a party alleging violation of his right to personal liberty by reason of police arrest and detention to supply facts sufficiently to establish that the party that allegedly reported the claim to police did in fact instigated the arrest and detention without lawful justification or reasonable suspicion of commission of crime. The facts and evidence supplied by the claimant are scanty and not sufficient to establish that the defendant reported the claimant to the police. There is also nothing before the court to establish culpability of the defendant in the report, if any, that led to the arrest and detention of the claimant. The case of the claimant was made worse with the claimant's failure to file reply to controvert the assertion made against the claimant that he absconded from duty without lawful justification. For the claimant to succeed in a claim for illegal detention, the claimant must establish that the defendant set the law in motion against him without reasonable or probable cause. The court will evaluate whether the defendant report to the police was a mere formal complaint or an active instigation of arrest. Under the Constitution, any detention must be justified by law. If the defendant cannot show the detention was lawful or that they were not primary movers, they may be liable for damage. In the case at hand, claimant has not tendered any evidence concerning report made to the police or the alleged report that was made on fraud, which he claimed was what led to the what was led to him being reported to the police by the defendant. The claimant had not shown what the defendant did to have him reported and arrested. In line with the Supreme Court decision in the case of Pajimere Kun versus Commercial Bank of Nigeria Limited, it is the constitutional right and duty of a citizen to report commission of a crime to the police. Liability for a breach of fundamental right under Section 35 of the Constitution only attaches to a private citizen if they actively instigated, directed, or took over the police discretionary power of arrest. The claimant failed to provide evidence that the defendant did more than lodge a complaint regarding the incident of 17th May 2020. From the evidence adduced and the above analysis, the claimant has woefully failed to prove relief B to be entitled to declaring his arrest and detention illegal, as the claimant was miserly with the facts that would have proved his case. In the circumstances, the failure of relief B means failure of relief D as well, which is a claim for exemplary damages. See the case of Udu versus Obondo Supra and McDonald Scientific Emporium Limited versus Access Bank, also Supra. In Relief D, the claimant has also raised issue of slander. In law, slander requires the claimant to prove that the defendant spoke defamatory words to a third party, which lowers the claimant's reputation. Exemplary damages are only awarded in cases of oppressive, arbitrary, or unconstitutional actions by government servants or where the defendant conduct was calculated to make a profit. The claimant must specifically plead and prove the defamatory words and the circumstances of publication. Failure to do so renders the claim for slander unsustainable. What Relief D depicts is a confusion and uncertainty of what the claimant wants to claim from the court. The law requires reliefs being sought to be stated distinctly with clarity. With clarity and not shrouded in ambiguity and confusion as to what it means to claim. In the entire evidence before the court, the claimant has not adduced any evidence to establish the tort of slander. He has also failed in that respect. From all I have been saying above, the claimant has failed to prove his claim before the court. Same is hereby dismissed for being frivolous and vexatious. I now turn to decision on counterclaim. On the counterclaim. It is right law that a counterclaim is separate, independent, and distinct action. Thus, counterclaimant, like the claimant in the main claim, has a duty to prove his counterclaim if he hopes to obtain judgment. In effect, the burden of proving a counterclaim is on the counterclaimant, as he is the party who would fail if no evidence is adduced to establish it. See MBN Limited versus UC Holding Limited. See also Obona versus Attorney General of Imo State and Oyabola versus ESO West Africa Limited. See also Prime Merchant Bank versus Mahmoud Man Mountain Company. See also Walter versus Skyly Nigeria Limited. Oroja versus Adeni. The initial burden of proof in a counterclaim, just like in the main claim, is on the counterclaimant, the party who wants judgment to be entered in his favor on the basis of assertion made in the counterclaim. Therefore, a counterclaimant bears the burden of proof imposed by the provisions of Section 131, 132, and 133 of the Evidence Act as amended. In respect of the said counterclaim, he make it the counterclaim must satisfactorily discharge the burden. The counterclaim will be liable to be dismissed where there is no proof of that. See the case of Tourist Company Nigeria Limited versus New Vista Property Limited. The counterclaim in its relief A is claiming the sum of 5 million naira is claiming for return of its items which were valued at the cost of 5 million naira. I have thoroughly perused the pleading and evidence of the defendant. There is nowhere the materials said to have been in possession of the claimant, which were not returned to the defendant, were itemized or enumerated, and the court, not being a soothsayer, is not in a position to say these are the items or on which these are the items the claimant has refused to return to the defendant. The counterclaimant has also not tendered any valuation report establishing the value of those materials or items said to have been in possession of the claimant. This means the defendant has not proved entitlement to relief E in the counterclaim. Same is hereby refused and dismissed. I note that also that relief was vague, vaguely drafted. It is uncertain. Court cannot grant an uncertain relief. See the case of Dr. Ike Goha, University of Jos versus Dr. Ike Goha. On relief B, which is for cost of litigation, this is a claim for special damages that need particularization and strict proof. There is no evidence adduced to establish that the counterclaimant did expanded the sum of 3 million naira, 500,000 naira in prosecution of this litigation. From the foregoing, the counterclaimant, like the claimant in the main claim, has woefully failed to prove entitlement to the relief being sought. This means that both the claimant and the counterclaimant have woefully failed to prove respective claims before the court. In the circumstance, not both the substantive claim and the counterclaim have failed and are hereby refused and dismissed. I make no order as to cost parties to bear their respective costs. Before ending that argument, let me say that I refrain from making pronouncement on the various submissions made by the council on dismissal and termination as argued in their various submissions. This is because there is no relief claim in respect of dismissal or termination. From the relief sought, which I have reproduced above, the bond of contention, whether on suspension and arrest and detention, and not on dismissal or termination of appointment. Judgment is hereby entered accordingly.
As the
As the
court
court,
As the
pleases.
court,
as the court pleases.
As God pleases.
My Lord, respectfully, I sincerely
Yes.
apologize for the device I was connected with earlier. I couldn't have my audio being heard. My Lord,
Okay.
I.J. Akiki is my name,
It's all right.
and I appear for the claimant.
Okay.
My Lord, I wish to thank my Lord respectfully for the judgment just delivered.
It's all right. You
My
are
Lord,
welcome.
we will take our time to look through it and also advise accordingly. Thank you, my Lord.
It's all right. You are welcome.
My Lord, we also appreciate your Lordship for the well-considered judgment, particularly on the issue of the preliminary objection. It's one that we really take into heart. We're most grateful,
It's
my
all
Lord.
right. You are
Thank
welcome.
Thank you, my lord.
Yes.
My lord, the next case.
Yes. Call the next case.
Yes, my lord. Suit number NICN CA 12/2026 between Union of Tipper and Quarry Employers of Nigeria and one Stephen Asunga Eso. Two, Desmond Oyanga Nso. Three, Basi Ndifon Inyang. For themselves and on behalf of persons operating under the name and style of Ecom Sand / Gravel Dredging and Tipper Union. My lord, the parties are absent.
Yes. Appearance.
May it please my lord.
Yes.
My name is Benjamin Edet, or the applicant.
Benjamin
Edet.
Edet.
Yes, my lord.
Yes.
My lord, we have a motion ex parte before the court.
Okay. What is it about?
My lord is praying for an order of interim injunction restraining the respondent from interfering with the jurisdictional scope of the applicant.
Yes. Why do you want me to issue an interim order of injunction? Ex parte? Why?
Yes,
Why do you want? What is the urgency in the matter?
my lord,
What is the urgency?
my lord, the urgency in the matter is that the respondents who are not a registered
Yes.
trade union have imposed levies on the applicant members who are a registered trade union. And due to the applicant members refusing to pay the levies, they have impounded their vehicles and have stopped them from working for over 3 months now. My lord, the applicant members, their livelihood is being
Mr.
seized.
Edet.
Yes, my
Mr.
lord.
Edet.
Yes, my
There
lord.
is nothing urgent in your case. The act has already been completed. So please, I want you to put them on notice. I will hear you next week, Tuesday. Put them on notice. We will hear you next week on Tuesday in open court.
As the
Put
court please,
them
my
on
lord,
notice, serve them. There is
my
nothing
lord,
urgent here. Urgency means you cannot get the party to serve him with your process. Once you can get the party to serve him, there is no urgency in the application.
As the court pleases.
That is what the law says. There must be extreme urgency. Extreme urgency means that before the date of the act that is to be restrained, you cannot be able to serve that party with your court processes. But once you can serve, you must serve, put him on notice. Once you do that, the matter has become sub judice. He cannot go ahead to violate the processes of the court. If he does, you know the consequences. So put them on notice. Put them on notice. This is a good case that you should put the parties on notice. Let them come and tell us why they are imposing levies on members of your association.
My Lord, we have actually filed all the processes. We have filed the motion for interlocutory injunction. We have filed.
Yes, that's why I said serve them with the originating process and the motion for interlocutory injunction. I will hear you on Tuesday.
As court pleases.
They will be served with hearing notice. They will be in court on Tuesday. At least when they are in court, they know that they cannot go and continue with their acts.
As court pleases. Thank you, my Lord.
Okay. This is a case that the parties deserve to be put on notice in the circumstance. I hereby order that the defendants be served with the originating process commencing this suit and the motion on notice for interlocutory injunction. This case stands adjourned to 21st day of April 2026 for hearing of the interlocutory injunction. I also ordered the defendant to be served with hearing notice together with the other processes. So, counsel, this matter stands adjourned to next week, 21st day of April 2026, to be had in open court. And the parties would be served with hearing notice against 21st.
As court pleases. Thank you, my Lord.
Yes, Register, call the next case.
Yes, my Lord. Suit number NICN CA 33-2020 between Ifechukwu Boys and Cross River State University of Technology, CRUTEC. My Lord, the parties are absent.
The claimant is present.
He didn't announce him. He didn't answer present, sir.
It's all
I am
right.
present.
Claimant in court virtually.
Yes, my lord.
Yes, appearance.
Most respectfully, my name is K.E. Omang for the claimant.
Yes. Yes. Any other appearance?
The defendant counsel is around.
You have counsel, you have muted yourself. Please unmute yourself for us to hear you. You have muted yourself. Touch your screen and unmute yourself. Check the speaker. You have muted. Okay. Yes.
With utmost humility to this honorable court, I announce my appearance for the defendant. My name is Patrick.
Okay. Yes.
My lord, the matter is for cross-examination.
Yes.
The claimant is on oath and he's ready.
Yes, my lord.
Mr. Akure,
My
are you
lord,
ready?
I still can't hear well, but I will go on, sir.
Meaning you have problem with your system? Because I can hear everybody clearly.
Yes, my lord. I can't hear, but I am ready.
But I am hearing you.
I can hear very well.
My lord, I will go
Yes.
on. Yes, my lord.
The witness should be reminded of his oath. Registrar,
Yes, my lord.
remind the witness of his oath.
Mr. Ifechukwu.
Yes, my lord.
Mr. Ifechukwu,
Yes, my lord.
you are hereby reminded of your oath to speak the truth.
Yes, my lord.
Yes, Mr. Ekuri, can we make progress?
Now, Clement,
Yes, my lord.
Yes, you had told this, in fact, stated in your statement of claim that it is the defendant who sponsored you to go abroad. That is true.
Yes, my lord.
Yes.
Now, you remember a letter written to Ted Fund, that you wrote to Ted Fund, dated the 28th day of April 2014, tagged application for nomination to Ted Fund academic staff training and development. You remember that letter?
I do not recall sending a letter to Ted Fund in 2014.
Now, I am asking you again. That letter is dated April 28, 2014. It is written by one Biose Joaquin Ifechukwude. Is that your name?
That is my name, my lord.
Did you write that letter?
I did not. April
You did
2014,
not?
I did not.
Okay.
Yes, my
My
lord.
lord, I refer to that letter. It is attached to our statement of defense. Application for nomination.
Is it an exhibit before the court?
No, my lord.
Now,
Mr. Ekuri, you say it's attached to your defense. The letter.
yes, my lord. My lord, it's in my statement of defense.
Okay.
No, let me even check. I think he attached it to his statement of claim.
He attached it to his statement of claim.
My lord, one moment, my lord. My lord, I can't, but that letter, my lord, is shown, my lord, in our statement of defense. It is dated April 28th.
Okay. Come. Yes.
Yes, my lord.
Can we make? Mhm.
Yes. Now, I don't know how to show that letter to you. If you can see it. Is that your signature?
That is my signature.
Or it was forged?
Sorry, my lord. Objection, my lord.
You what?
Objection, my lord.
What are you objecting? He's just asking him.
My lord,
He's
that
asking.
document is not an exhibit before you. The document
said?
is not
Now-
an exhibit before
He
you.
Now,
is-
have you seen, did you have our statement of defense served on you? Did you see it?
Yes, I saw it, my lord.
Did you see that letter?
The letter that you are saying I signed.
Okay,
No,
now how did you
no, I did
apply,
not.
since you want to deny, how did you apply for TED Fund's sponsorship?
I completed a nomination form, TED Fund nomination form. It's a standard TED Fund form that was completed by myself and given to my sponsors. It's a nomination form. It's very standard. And I have a copy of it.
So you still stand by the fact that the application for nomination was forged by the school, by the defendant?
My lord, the application for nomination is a standard form, not a letter.
Oh, okay. Now, if you call it a standard form, you are now saying that this letter here to the Vice Chancellor of the defendant through the Dean, Faculty of Basic Medical Sciences, Okuku Campus, that's to TED Fund, is forged by the defendant.
I do not have a copy of that that letter, so I cannot say whether it is forged or not. But I know that TED Fund.
I can't hear.
I know that TED Fund has a standard form, a standard nomination form that is completed by the applicant or the nominee, which is also countersigned by sponsoring faculty members of his department or faculty, and forwarded to the registrar's office for
I'm
approval.
sorry, my
and
lord,
routing
I
to
can't
TED Fund.
hear very well. My lord, can we have a stand down? Let me drive to the court. Maybe I can get some help there. I can't hear very well. A stand down of less than 10 minutes, I'll be there.
Okay.
I'll come. I want to come to court. Maybe I can be assisted. I can't hear.
The council, if you've answered call while the Zoom meeting was on, that is the problem. If you can switch off your phone and on it back, then log in.
So please let me come to court. In less than 5-10 minutes, I'll be there.
It's all right.
Okay, sir.
Please let me come.
Granted.
Thank you, my lord.
As the court pleases.
Registrar. Registrar,
Yes, my lord.
get in touch with this man so that he will not discontinue with the.
My lord,
He will
I'm
not
here.
discontinue with the meeting, with the hearing.
Yes, my lord.
Get in touch with Fatai. that he should
Fatai,
not discontinue. We are having
yes,
just
my
a
lord.
10 minutes break.
Yes, my lord.
My lord,
You say? Yes, counsel. What are you saying?
no, my lord, I thought you wanted to tell me that I should not leave the meeting. I heard
No,
everything.
not
I'm
you.
following.
I said I told the registrar to call the administrator of this meeting that they should not discontinue with the meeting.
The God
You
pleases.
know, this meeting is being controlled centrally from Abuja.
Yes, my lord.
Okay.
Don't believe. And the person, origin.
Hey, well, I'm
I
not.
don't feel the doctor kind of. I'm not gonna blame as if I'm going to go and
I'm no problem. Say, I'm not the man now. Hey, I know this brother. We need to make sure they don't talk, don't breathe. No, we don't discuss. What do you want?
It is never know the any audio.
Lamu na para canton of more. Kaja la canton of yes. Kaja la no di mo. Make you wash up, clean up. I don't green, no green. I dey change it. Yes. Ati bala wala for about 150.
for free.
For free. Come be stay. But I can't bla bla. You must send me in the world.
I want our matter in so all.
Oh God.
Matter in so
You
all.
don't finish.
The Zoom meeting not finished.
No, resume it. We see they continue, but they don't finish our
People are
matter. So our matter in so all those allegations of million. Now our matter.
So this talk na for what?
Now we just start on now.
For Calabar.
But
see here, Calabar.
You don't tell me things.
so yeah, you know the terracing now.
You say no, you don't be person, but you don't nobody know.
You see, no,
I'm not going to watch one more watch and live. Sanusi Kado. That was that voice. What the so?
Oh.
The meeting I did not want you see the pass code. Okay, now the link. Right?
So then you got around it. So
I
try to open
don't
up.
join the meeting, but no.
Oh, yeah,
The meetings whether I get admin or whether they admin they even know how to.
I beg. I will get a CTC of this church. Come collect them.
So you say what you watch.
I think that they talk so as I hear. I think that those kind of those.
Okay.
Yeah,
now this one.
let's say the
Don't tell me don't explain something to a person. I mean, yeah, nothing that didn't matter. I mean, that judgment, that CTC now copy now for don't
But start this video now. That is now.
because the last one when they show me say any judgment when they pass anywhere, you cover all of us. I think the last judgment they tell me so. Someone will tell me say now they pass judgment for Calabar
matter with this now. So
you learn how to give information.
So what do you judge?
the judge in all the bracket and say they cannot
No, got a time. Yes, I can see the screen. Okay.
Yes, counsel, I will sit.
Yes, my lord. Thank you, my lord, for obliging me the opportunity. Yes.
Okay.
Thank you, my lord. My lord, it's just that it is very hot here. I hear there hasn't been any light here since yesterday.
No light.
No light since yesterday, sir. Very hot.
Right. Even here, it's not from NEPA. Even here, I'm not using NEPA. It's solar.
Oh, okay. Volume.
Yes, can we make progress?
Yes, my lord. Okay. Now, please look at that letter on display now.
Yes, my lord, I can see.
Please, can you bring it down, the letter?
Yes, witness, have a look at the letter on the screen.
Yes, my lord, I can see it.
And this one go out.
Okay. Yes,
Okay.
scroll down.
Run down.
Yes, it's okay.
Please, is that your signature or it was forged too?
It is my signature, and I recall this letter.
Oh, you recall the letter.
The letter.
You now agree that it is your letter.
On display.
Yes.
I can recall it. The signature.
What?
Signature on it is mine. Yes.
Yes, my lord,
Now,
it
by
is
this
mine,
letter,
but
oh, sorry.
the lawyer had asked me, the question was that I sent the letter to TEDFund. And that's why I answered in the negative, because this letter was not to TEDFund. The letter was addressed to my vice chancellor for nomination for sponsorship. As
okay. I was
can be
asked
seen.
before, I was shown the letter that I sent it to TEDFund. That's what informed my earlier response. But this letter was addressed to the Vice Chancellor. Yes.
Now, would you know if the letter was forwarded to TEDFund, nominating you?
I would not know if this letter was forwarded to TEDFund. This letter was accompanied with the standard CUTEC form, as it was then known, called the nomination form to TEDFund. So I had no direct communication with TEDFund. My sponsorship and dealings laid clearly at the office of the Vice Chancellor and the Registrar of CUTEC at the time.
Yes.
Now, who sponsored you? Is it the defendants or TEDFund?
The
Who paid
defendant sponsored
your
me.
fee?
Yes.
The defendant sponsored me because they directly related with me what my sponsorship terms were, hence the bond form an agreement entered into with the defendant.
Yes. Any other question?
Did you write to a letter to TED Fund asking for supplementary funds? Since you now deny that it is you don't know who sponsored you, that TED Fund did not pay your fees, it was the defendant.
On advice of the then desk officer at the office of registrar's office, I was told to apply for supplementary fund. I do not recall if it was directly to TED Fund, and I don't know that TED Fund has ever communicated with me directly. Communications to me has been from the
It
defendant.
appears your network is.
Can you?
My lord, I can hear you. I'm following the proceedings, sir.
Witness.
Yes,
I
my
did
lord.
not hear your answer because your network was plenty.
Okay, I would make myself. So, my lord, I
He is
said that.
having problem with his network.
My lord.
Yes, witness.
My communications had been directly
I said
with
I
the
did not hear
defendant,
your answer.
not with TED Fund. I said my communication has been with the defendant, not TED Fund.
Yes, I have recorded you. I have recorded that.
Okay, my
Yes,
lord.
Mr. Ekuri, any other question?
Oh, yes, my lord, plenty, sir.
Mr. Ekuri, any other question?
Now, do you have any agreement with TED Fund that you now deny, or the defendant, that you are going to be paid the 28 million naira in pound sterlings?
I have agreement with the defendant, not TED Fund.
Please, what agreement? How did you have a letter to that effect?
Yes, I have a letter from the office of the registrar of the defendant to the High Commission or the embassy for my visa application to the UK embassy. And that was from the defendant, not TED Fund. And in fact, to this day, I have no record of any communication from TED Fund directly. I have no paper trail whatsoever.
Hold on. The court is recording it. Sorry, my lord.
Yes. Yes, any other question, Mr.
Respectfully,
Ekuri?
my lord.
Yes.
The letter in question he is making reference to is dated 30th September 2014, Exhibit C4.
Please read it.
Mr. Ekuri,
The
any
letter
other
in question is Exhibit C4, is dated 30th September 2014.
Mr. Ekuri, any other
Now,
question?
how much was approved for you?
My knowledge.
Was it in naira, and how much was, yes, okay, go ahead.
I would rely on the letter to the High Commission. I think it was stated, give me a second, let me that letter up.
Yes.
It was to the tune of 106,640 pounds sterling. If you look at the letter dated September 30th, 2014, from the defendant to the Honorable Commissioner, British High Commission, Visa Section.
What he was asking you is how much was approved for you for your
Yes.
studies.
The communication that was made available to me in writing is
He's
what I
not
just read out.
asking you of communication. You should know how much was approved for you.
I did not receive any communication from TEDFund directly. I am in no possession of such. But I am aware that the defendant,
Well,
my lord,
he is not asking you. Listen to him. Please listen to question when they ask you. Listen attentively. Understand the question before you answer. If you don't understand, say you don't understand. Mr. Ekuri.
Yes, yes. Now,
Mr. Ekuri.
Yes, my lord.
Mr. Ekuri.
I can hear you, my lord.
Repeat your question.
Repeat your question. Yeah, my lord. I asked him how
I said,
much.
can you repeat your question so that
That is what I'm doing. I'm doing, my lord. Now, how much was released by TEDFund to the defendant for you?
106,640 pounds, 4 pence, my lord.
Okay. Yes. Yeah.
Yes.
Would you know if TEDFund released the money to the defendant in Naira or in pound sterling?
I am aware that the money was released to the defendants in Naira, and a letter compelling the defendants to convert and hold the sum in the denomination or the currency that the sponsored fellow would expend such amount.
Do you have that letter?
I do not have a copy of it. I had asked the desk officer copiously for a copy of it, and it was held back from me. In fact, in my telephone conversation with the vice chancellor at the time, Professor Waneno, I had made request for that letter, even to the chancellor at the time, Dr. Emil Ian. That letter was not made available to me.
And you are sure? So where did you get that assumption that it was
know because
mandated
I have
that it should be held? They paid you through your Naira account. That is true.
That is correct. That information was made available to me via the regulatory document from TEDFund, and I also have conferred with other sponsored students from other federal universities and state universities in Nigeria.
Did you state all of this in your statement, in your claim? About people
I remember that I said I was going to rely on the letter from TEDFund confirming fund release.
Oh,
something to that effect.
Okay, you have the letter from TEDFund?
I was going to rely on that letter, which will be provided by you.
Oh, did
by
you?
the defendant,
Okay.
I should say.
Did you give the defendant notice to produce that document?
I had communicated
No,
verbally
my lord,
to the
somebody
vice
is talking
chancellor.
in the background.
I had communicated
My lord,
verbally
somebody
with
is
the vice
talking in the
chancellor.
background. Sorry, Biose. My lord,
Yes.
somebody is talking in the background. Somebody's
Which
providing
background?
answers in the background, sir.
Yeah.
No,
Mr.
Biose,
The
it's not
answers
you.
are
Don't worry.
inaudible.
Biose, don't worry. Don't worry.
Witness.
Yes, my lord.
Made
My lord,
available
somebody's
yourself,
providing
please.
answers in the background.
Always let your camera be on.
My lord, my
Yes,
camera
my
is
lord.
That's
on.
why I'm saying you
I
should
don't know what
always
the learned
make
person meant.
available it.
My lord, my camera is on. I'm not providing answers. I don't practice in that manner. I'm
I
not.
didn't
and-
mention you. I didn't mention
Yeah.
you. I didn't mention you. I know you heard those answers given. I know you did.
No, I did not. My lord, I will go mute again.
Yes, let's make progress.
Yes. Now, you remember you had
Yes.
written a letter
Witness.
to the defendant saying that
Yes, my lord.
that's admitting that all the monies were given to you, but a lot of things happened because of rising dollar rates, our pound sterling rates, and all that. And that is why the benchmark issue and tuition and everything made it fall short. That is true.
That is true, but it is also true that the defendant ought to have held the fund in pounds sterling, not naira. And I had made this case copiously in writing to the Vice Chancellor and to the registrar, as directed by TED Fund. In fact, it is one of the statutory regulation by TED Fund at the time to hold such funds in the currency for the country to which these fellows were sponsored.
Do you have that document?
I can
Do you
provide
have
a
the document?
I do not have the direct communication between TED Fund and KUTE, but I have document, it's open source of TED Fund's requirement. And I can provide letters, if I'm allowed, from other students in other institutions in Nigeria, where it was so stated. I am very sure if the defendant can produce that communication of sponsorship from TED Fund concerning my case, the court will see clearly where it was so stated that the funds must be held or should be held to avert.
Yes.
So how were the funds? I'll ask you again
inflation.
for purposes of clarity. How were the funds transferred from TED Fund to defendants? You have said it was transferred in naira. So how come TED Fund did not transfer the money or the funds to you in pounds?
So that I am not TED Fund. But if you also go to my open letter to the president at the time, President Mohamed Buhari, and it's open source, I stated this very clearly. I think it was retweeted by Ruben Abati of the now Arise TV in 2017. So if I had said anything that was against regulation of TED Fund, I'm sure somebody would have made a rebuttal. But that rebuttal never came. And if the defendants would so provide the court with the communication between TED Fund and them, these very salient points would be highlighted and clear to the court.
Yes, any other question, Mr. Ekuri? Mr. Ekuri, any other question? Mr. Ekuri? Mr. Ekuri? It appears Mr. Ekuri is offline. Mr. Edith, can you get in touch with him to find out what has happened?
My lord,
Mr.
the laptop we were using went off all this.
Okay.
Yes, my lord.
It's back, my lord.
Yes, Mr. Kure, any other
Yes,
question?
I can see. Yes, my lord. There. Yes. Now, when were you supposed to get back to your duty posting with the defendant?
As soon as
2017.
no, as soon as my PhD was finished,
When
and that was
when were you supposed to get back? That is a very simple question. When were you supposed to return to Nigeria?
my lord. I'm trying to answer the question. I was supposed to return to Nigeria when my PhD was completed.
That's not my question. When was it scheduled for you to return? It was a 3-year program. That is correct.
That is correct, and that would have
So
been.
now, when
That
did
would
you
have
leave?
been.
When did you leave Nigeria?
I left Nigeria on either 3rd or 4th of January 2015.
Yes, and in 3 years you were supposed to get returned to Nigeria, to the country, to the defendant in 2017. That is true.
That is incorrect.
What is
2014,
correct?
2015 January to 2017 is not 3 years, my lord. It is in fact 2 years. January 2015 to 2018 would be 3 years, my lord.
So when did you? In 2018, you still didn't come. You still didn't return.
Because I had not finished my PhD at the time.
In 2026, you are still not finished your PhD.
I finished my PhD in June 2019.
And since till 2026, you have still not returned to the defendant.
Because I am in debt and the defendant has not given me what is due me. My hardship
How much is the
was well
defendant owing you?
communicated to the defendant.
How much is the
It's in
defendant owing you?
It's well stated in my claim statement.
How much is the defendant owing you?
I would like my memory refreshed because it's clearly stated in my claim statement, my lord.
Now, how much damages are you asking for?
Yes,
How much damages are you asking for?
you say?
How much are you
He's
asking for in
asking
damage?
you how much was it that they have not paid you?
Sorry, my lord. Respectfully, my lord. My lord, this case was filed in 2020. The witness will need to be refreshed his memory with his statement of
It's his case
defendant.
now, not the dependent case.
Yes.
He's supposed to know his case. And he knows he's
Ma-
coming to testify. He's supposed to have all his facts with him.
My lord, may I
Is it
respectfully
not
apply
his
that?
case? He is the owner of the facts. He is the owner of the facts, not counsel. Yes, witness. How much
My lord,
was it that?
I'm trying
Yes.
to jog my memory.
If you cannot remember, say you cannot remember. Simple will pass. We'll continue.
I cannot remember. I cannot remember.
Okay.
Yes, Mr. Kure,
Now,
any other question? Yes, Mr. Kure.
my lord, just a few more, maybe just one more. To Krutek, I mean to Tetfon through the defendant.
Yes.
Witness, can you hear me?
My lord, I did not hear
Yeah.
that. Could you please?
I said you
Ask the
made a supplementary letter to TEDFund through the defendant asking for more funds.
Yes, that was on advice of the then desk officer of TEDFund at the registrar's office.
Yes.
Now, did you or did you not write that letter?
Wait. I wrote a letter for supplementary grants to TEDFund through the defendant on advice of the desk officer. Yes.
But
So
my lord, I would like to be reminded if that letter was written directly to TEDFund or to the vice chancellor. Just so
I'm looking for the
I can be
letter.
factual.
No, I'm looking for the letter. Wait.
Thank you, my lord.
Please just hold on. I'm sorry, my lord. I'm looking for the letter. I'll get it soon. Yes, my lord. I'm looking for the letter. I'll get it soon, my lord.
Yes, we are waiting for you.
Yes, my lord.
Was it in the statement of let me see.
Oh, yeah, yes. Look for defense, yes. Sorry, my lord. You can see that, yes, sorry. Sorry, my lord.
I've seen emotional outbreak.
Yes, Mr. Puri, do quick.
Yes, I'll be with you, my lord. No. Sorry, my lord.
Submission of document and publication of TEDFund.
Supplementary funds application. Okay. Okay, good. Please, that letter you wrote is dated the 31st day of May 2016. Do you remember the letter? It is
Yes,
signed
my lord.
by Biose Ife Chukwude Joachim.
That is correct.
Yes, it is headed welcome. I welcome surgical that, so I'm sure it's from you, United Kingdom, to the Secretary, Tertiary Education Trust Fund, Abuja, Nigeria, through the Vice Chancellor, Cross River State University of Technology, RUTEC, Calabar. You remember that letter?
That is correct.
Good. So if you were asking for supplementary funds, it is true that what you had, what had been released to you was not enough. From what you have said, due to rising exchange rates, that is true.
On advice of the desk officer
No,
at the
no,
registrar's
not
office.
advice. Please, you are the witness here. You are the person involved. This is not a witness or trying to help your case. It is you. You denied or you wanted to be refreshed on whether this letter was written to TED Fund. And we are using the word supplementary PhD fund, written by and signed by you. So I have asked you a very simple question. If you are asking for supplementary funds, I am even on your side to say that it means that what was approved and released to you was not enough. And then, like a supplementary admission, when the first list has been done and all that, they now bring in an addition. So that is what you were asking for because it was not sufficient due to what you call rising exchange rates. That is true.
It is true that the letter was written by me to TED Fund Executive Secretary through the Vice Chancellor. That is true. What is also true is that it was written on the advice of the desk officer of the registrar's office. And what is even more true is that the reason for supplementary fund application was occasioned by the defendant's refusal to adhere strictly to the tenets of TED Fund, which is to hold the funds in foreign currency, in pound sterling, that is. That is true.
Yes. Any other question? Mr. Ekuri, any other question? Mr. Ekuri? Mr. Ekuri? Mr. Ekuri? Mr. Ekuri? It appears Mr. Ekuri is offline. Yes, counsel for the claimant.
Yes, my lord.
What do we do? It appears Mr. Ekuri is offline.
He has informed us that that was his last question.
No. Get in touch with him, find out what has happened. What is it?
All right, my lord. All right.
Yes, have you gotten him?
Yes, my lord.
What did he say?
I think his guardian went off again.
Let him reconnect back.
The court officials are trying to help him. Come call a puri number. I don't want to open my network. That's fine. 080 37 14 57 61. You busy your caller? I think he's back.
Huh? Hey, are you in the office?
Yes, my lord.
Go and tell Victoria why has she gone offline.
Okay. He's busy in the caller. Koti, he's trying to connect.
Yes, Victoria.
Okay.
Yes, Mr. Ekuri.
Yes, my lord. If I can be heard, sir.
Yes.
Okay. Now, please, before network went up, we're talking about
He's talking of the reason why he wrote letter for supplementary fund. Mr. Ekuri, you have muted yourself. You have to unmute yourself.
yes, my lord, I have, sir.
Okay.
Good.
Yes.
Now,
Any other
witness.
question?
Yes, witness. In that letter, the supplementary letter you talked about, you wrote to the school, did you in any way or in any portion of that document report to TEDFON that the defendant has not done what he was supposed to do?
No, I didn't. That's because the facts of the matter came to light after that letter was sent out.
Oh, did you now make any other reports to them till date?
Yes, I did. In fact, I wrote to the then Dr. Baffa, who was the executive secretary of TEDFund, out twice, and myself and my PhD advisors spoke with him on 2 occasions, and his response was, TEDFund as a policy matter do not directly relate with students or sponsored members of faculty.
Okay,
They
you
deal
you
directly
didn't
with
write to him. There was no written communication
There was a written communication.
with him. Did
Yes,
you state that anywhere in your statement of claim?
I believe it is stated there. I want to believe so.
I have your reply. I have your amended statement of
Sorry,
claim.
my lord.
You amended.
Sorry. Respectfully, sir.
Yes.
They are contained in his statement of fact. And
What is contained in statement of fact?
where he complained that they have not paid the school fees and they have not released money as they're supposed to. My lord,
Paragraph
if you
what?
look at, I'm coming, Exhibit 10, Exhibit C10, Exhibit C11, his supervisor sends mail concerning that. It was pleaded in paragraph, just 1 minute.
Yes, Mr. Kuri, you have gotten a
My lord,
response that he has sent it, he has
paragraph 14, paragraph 14, paragraph 13, paragraph 13, paragraph 14.
Yes.
Is contained there.
Mr. Kuri.
Yes, my
Any
lord.
other question?
My lord, I'm looking at paragraph 14, where he said,
yes,
concerned about the claimant's predicament, the claimant's PhD supervisor, Professor Myrie McRae, joined in attempting to persuade the defendant to pay the claimant's tuition. Now, witness, did you
Yes, my lord.
inform Professor McRae that all that was you were entitled to was paid to you?
I did not inform Professor McRae that because it is not true. My 3rd year tuition was not paid. 2 years of maintenance was not paid. And that also ties in with the earlier question you asked me about when I ought to have finished. And that occasioned my delay in finishing. I spent more time doing my PhD because I couldn't even do my experiment or had the mental focus to write up my experiments thereafter because of lack of maintenance for 2 straight years.
The
And
court is recording you. Go gradual.
No, please,
counsel,
counsel, don't do
you are
this.
not witness in this case.
Don't get
Allow the
involved.
witness to talk. Yes.
my 2 years of maintenance was not paid. 2 continuous years of maintenance was not paid, and my last year of tuition was not covered.
So was that who was supposed to pay the money?
The defendant. The defendant
Oh.
with whom I entered a bond agreement.
Yes. Now, everything that was handed over to by TEDFund to the defendant was released to you.
I would not agree.
106 or 28 million was released to you, and that is why when, for whatever reasons, you could not meet up, you now ask for a supplementary payment to TETFON.
My Lord, I don't believe, I do
Yes,
not believe
witness.
that the total sum of £106,000 was released to me.
How much was released to you?
I cannot recall, but I know for a fact that the total sum of
Yes, witness.
£106,000 was not released.
Yes. So if you had told Professor Macrae the truth about the entire thing, especially that there were issues of rising exchange rates and everything, he would have had a different opinion. That is true.
I do not believe so.
What do you believe?
I believe that Crutech held my sponsorship fund in Naira. And I also believe that they failed, in addition to that, to cover my tuition for my last year, and also they failed to cover my maintenance for 2 continuous years.
Do you have any evidence of the fact that all of that was not paid, what was released was not paid to you?
I have evidence to the fact that my 3rd year fee was not paid by the defendant. I have evidence to the fact that my 2 maintenance years in payment was not released by the defendant.
Okay. Now, this letter of supplementary fund you wrote to TETFON, did they reply that letter?
No, I was made aware of no such communication in response to my letter.
You say you were what? I didn't hear that.
I was not made aware that my letter was either received, sent, or received, or a letter written back in response. No communication whatsoever.
Oh, okay.
You are not made aware of what?
That the letter was sent to TETFON?
Your network is ceasing.
I am not aware. I was not made. Can you hear me, my lord?
Yes, you are not made aware of what?
That my letter for supplementary release of funds was sent indeed to TETFON, and I have no communication to indicate that they had received or acknowledged the receipt of the letter, let alone reply to the letter.
It appears we are having problem with the network.
My lord, I'm here.
Yes.
My lord, I am here.
Mr. Akuli, are you online? Yes. Mr. Akuli, you have muted yourself. You have muted yourself. Unmute yourself. Mr. Akuli, unmute yourself. Yes. Unmute yourself.
Unmuted.
Yes.
Yeah, my lord.
Yes. Please, I think
Yes, my lord, I
network
said
is...
that is all for the witness from me, sir.
Okay. Okay. Mr. Edit, any examination?
My lord, one.
Yes.
One re-examination.
Okay. Yes. Go ahead.
Witness. Yes.
Yes, my lord.
The defendant asked you if all the monies were released to you. It did not separate whether school fees or maintenance and all of that were released to you.
My Lord,
And you
I
answered
object to
generally.
that, sir.
Please kindly
My Lord, I object.
kindly help
My
the
Lord,
court
I object to
understand
that.
if the defendant paid school fees
My Lord,
directly to
my Lord, there
Glasgow,
is no
or they also
ambiguity
release
in that
all.
question. He answered
Counsel
the question.
cannot be talking at the same time, please. One has to finish before the other talk.
As the court pleases.
The court pleases.
Yes.
My lord,
Yes.
should
What
I
is your
answer the question?
objection?
My Lord, my re-examination question.
Okay.
The re-examination question is
What
this.
is your objection?
My
Lord,
objection is okay.
Who is going first now?
No, you can talk. You can talk.
Mr. Ekuri, what is your
Yes,
objection?
my Lord. My Lord, I object to that line of re-examination. My Lord, the question was asked and was clearly answered. So an attempt at this stage, my Lord, to now begin to separate this or separate that, my Lord, it's not, that was not my question. My question was clear, whether what was due him was released to him. So this aspect of differentiate differentiate that and everything was not asked by me, and that cannot come up now. My Lord, there is no ambiguity to it.
No, Mr. Ekuri, there is a need. There is need to have clarification. If you said all you have paid, all has been paid, and he said yes, and he now said that no, not all. There are certain, we need to know.
My Lord,
we need to know. Because that's why he is in court. If he has been paid all what he's entitled to, he wouldn't have come to court to do what?
As the court, please.
If he has been paid, what is he coming to do in the court? Yes, Miss Witness, what is your answer?
My lord, my answer is...
He had answered that question, my lord, which is prejudicial to me.
I say I have overruled your objection. I have recorded you objected. I say I have overruled it.
As the court, please.
Yes, witness.
My lord, my third year tuition was not paid at all by the defendant.
You said?
My third year tuition was not paid at... My lord?
You have told me that. Don't tell me that again. That is not clarification. You have already told me that. I have that on record.
Ah, I see the question. Okay.
Counsel, you are not witness in this case. Allow the witness to
talk. So animated.
Okay.
You have asked him question. Allow him. He
my
has
lord,
already told me that he has not been paid his tuition for Sadia, and he has not been paid 2 years for maintenance. Is that not? Is there any other thing you want to say?
Yes, my lord. I would like
All
to
those
add
ones
that
are already on record.
I would like to add that my tuition was not paid directly to me. It was paid directly to Glasgow by the defendant for the 2 years that was paid.
Your tuition was paid to the school.
To Glasgow University directly by the defendant, not through me.
To whom was the tuition paid? To whom?
To the University of Glasgow.
But that is not the issue. That is not the question he's asking me. If it has been paid to the university, it means it has been paid to you.
For the 2 years tuition, it was paid directly to the university. the third year was not paid. I think that's what my
This is not even the. I'm sorry, my lord. This is not even the question asked in re-examination by his own lawyer. My lord is using the
Yes, that is
opportunity
not the question.
to.
That's why I have not recorded him. I said that's
And
why
the
I have
court
not
please.
recorded him.
My lord, no further question. My lord, no re-examination, no further question. It's okay, my lord.
Okay, okay. No re-examination by edit. CW1 discharge.
The court, please.
Yes. So what is it?
Mr. Edit, where is your next witness?
No, my lord, that would be the case of the claimant.
Mr. Ekuri, where is your witness?
My lord, we did not anticipate that it will get this way. My lord, we'll take a date and bring our only witness. We have one witness, my lord.
Registrar, give us date.
May 5.
You say? Hello, Victoria, what date? Date for adjournment. You have muted yourself. I can't hear you.
My lord, 5th of May.
Is that convenience for the parties?
My lord, it is convenient for me.
That is convenient.
This case is hereby adjourned to 5th of May, 2026 for defense.
As the court pleases.
My lord, will it be online
Yes.
given that?
No, it will be in the open court now, unless you want it to be online.
Well, no, my lord, I will be in court. Thank you, my lord.
Okay, you are welcome. Yes, any other matter?
That's all for today, my lord.
Victoria, any other matter? Huh?
No, my lord, that's all for today, my lord.
Okay, counsel, thank you for your cooperation. We have come to the end of today's proceeding.
Oh, God. And now this thing will be meted again.
That the batteries.
Maybe it's weak. Because when you brought it, the battery was less than 50%. On the no, it's not even logged in. No, it's just there. The one that's yes, is even they displayed it on the phone for they've made things easy now. Everybody. Sure.